session for the July, what is today? 26th CBA meeting. So back on the agenda, we are at item number 11. Actually, before we begin, we'll go ahead and do a roll call to ensure we have a quorum today.
Doug Aguilera,
Present.
Patricia Batchelor,
Here.
Nancy Dong,
Present.
Carrie Ann Farrell Hines, Dan Jacobson,
Here.
Christian Lotta,
Present.
Joe Rosenbaum,
Here.
Katrina Salazar,
Present.
Teresa Thompson,
Here.
and Yin Tu.
Here.
We have a quorum.
Okay, great. So allow me to read a couple of things. First of all, taking public comment. The CBA has provided the opportunity for the public to participate via the WebEx platform. When we take public comments, we will begin by taking public comment from those individuals attending the meeting at the Sacramento location in person. I will then ask the moderator open up the lines for public comment for those participating via WebEx. You'll be allotted up to 5 minutes per public comment. Okay, so next item on the agenda is item number 11, and we've got 3 reports from the enforcement chief. So, Carrie, okay, we'll do item A, the enforcement activity report. Corey Reardon, Deputy Chief.
Good morning. I am Corey Reardon, the Deputy Chief of the Enforcement Division. The activity report before members today is the first 11 months of the fiscal year 2023-24. Starting with complaints received on page 1, the complaints received was 5,262 complaints. The graph on the bottom of page 1 provides a comparison of the total complaints received as of the same reporting period for the 2 prior fiscal years. Members will see, compared to the prior fiscal year, we have received a 31% increase in complaints over the same period. On page 2, we have included information on the top 3 complaints, with complaints regarding unlicensed activity being the most common. Moving on to investigations and investigations pending on page 3. At the end of the first 11 months of the fiscal year, staff closed 5,827 cases, with 96% closed within the first year. The average days to close investigations was 109 days, and enforcement had 1,528 cases pending in the investigations pending inventory. Of the 3 pending cases over 24 months since this report, 1 report was referred to the Attorney General's office, 1 was closed, and 1 investigation is ongoing. Moving on to discipline. Discipline-related information can be found on page 4 of the report. Looking first at the AG referrals, the CBA referred 41 matters to the AG and filed 26 pleadings. The CBA had 45 matters pending at the AG's office. Moving on to citations on page 5, the CBA issued just over 1,000 citations. 84% of the citations were due to failing to comply with the 20 and 12 continuing education requirement. The CBA received 112 citation and fine referrals, and we have withdrawn or modified 62 of the citations based on those appeals. In most cases, the licensees either provided new mitigating evidence or complied with the issues that resulted in the issuance of the citation. On page 6, we have information regarding unlicensed activity. The CBA has received 2,157 complaints regarding unlicensed activity. We have closed 2,862 investigations through the first 11 months of the fiscal year, with the majority closed as a result of compliance. Final area of the report I'd like to highlight is on page 7 and is related to probation monitoring. As of May 31st, 2024, We have 61 licensees on probation with no new probationers since the last report, and 8 probation orientations have been completed. We have identified 44 probation violations, with the majority being failure to comply with quarterly reports. At this time, I'd like to turn the discussion on this item over to President Rosenbaum, and I'd be happy to answer any questions members may have.
Thank you very much. Okay, Ms. Chu, you have your hand up.
Yes, thank you, President Rosenbaum. When you mention unlicensed activities, and it sounds like most of them closed um, due to compliance, can you define that for me a little bit? Unlicensed, does that mean they no longer practice accountancy, or is it we have some kind of resolution in terms of fines, or can you just clarify that for me a little bit?
Compliance could be for a variety of reasons. We may have reached out to the individual and they have complied with the order of correction that we've requested of them.
And that order can be anything. It could be that they have to stop practicing, or is it mostly because they did not do their continue education and they have to finish their education?
It could also, one of the common things is they're practicing under a firm that's not registered, and then they register the firm to become in compliance. So that's another common that we see.
Any other, Ms. Dong?
Yeah. You probably don't have this tracked, but maybe NASBA or AICPA would have this information, just to know if there are any comparables. So have you looked at how the enforcement statistics compare to, say, New York or Washington, DC, just to see if we're tracking the same way, trending with higher numbers, or if their
No,
levels are the same? Mhm.
we don't have that information.
Yeah.
That's something we could consider.
Any further questions? All right, thank you. We'll reserve public comment for any of these 3 items in agenda item 11 until the conclusion. So item number B, and continuing with some of the things that we've heard from staff over the last few meetings, to give us additional background into some of the workings of the CBA staff. We're going to have an overview of the enforcement process and the role of the California Board of Accountancy members by Carrie O'Connor, the Chief of the Enforcement Division.
Thank you. Good morning. The purpose of this item is to provide members with an overview of the enforcement process and the role of CBA members, and there's no action needed for this item. Starting with a brief overview of the enforcement process, which is detailed in attachment 1. When the enforcement program receives a complaint and establishes jurisdiction, the complaints are assigned for investigation. The purpose of an investigation is to gather facts and make assessments as to whether there are violations of the California Accountancy Act and Code of Regulations. The enforcement process concludes when the matter is closed and a citation and fine could be issued, or the CBA proceeds with formal discipline by referring the matter to the Office of the Attorney General and requests the filing of an accusation. Now I'll discuss the formal discipline and the role of the CBA members in that process. So disciplinary actions are considered by CBA members during closed session at each CBA meeting. CBA members will review and deliberate on the documents received for each disciplinary matter and consider guidance or information from CBA's legal counsel, a representative from the AG's office, or myself, the enforcement chief. CBA members serve as the decision makers during the enforcement process. When CBA members are considering disciplinary action, they should give the utmost consideration to consumer protection. Formal discipline matters are resolved in one of 3 ways: a default decision, a stipulated settlement, or a proposed decision. First, I'll start with defaults, and then I'll go into the role of CBA members with that process. When a licensee does not timely file a notice of defense or fails to appear at the scheduled administrative hearing for the matter, a default decision is prepared by a Deputy Attorney General for consideration by CBA members. CBA legal counsel will present the default items in closed session and is limited to providing CBA members with advice on procedural and legal issues. The role of the CBA members in this process is to make their decision based on the record provided. If the CBA members adopt the default decision, the licensee may serve a written motion within 7 days of the default being served, requesting that the CBA members vacate the decision. And then CBA members may vacate the default and grant a hearing on a showing of good cause. Moving on now to stipulated settlements. This is a negotiated agreement between the enforcement program with the assistance of the AG's office and the licensee where the parties agree on a resolution to the matter. The enforcement program uses the disciplinary guidelines and model orders when drafting and negotiating these stipulated settlements, and those guidelines are provided as attachment 2. The role of the CBA members is to make their decision based on the administrative record, and they may also discuss cases involving stipulated settlements with the enforcement chief prior to deciding on the cases. For all stipulated settlements, the CBA has the following options: adopt the settlement, reject the settlement and direct the matter to be set for hearing, or reject the settlement and offer a counter proposal for the respondent's consideration. However, if an agreement is not reached, then the matter will be set for hearing. Next, we'll discuss proposed decisions and the role of CBA members in that process. So a proposed decision occurs when a licensee files a timely notice of defense and the case is not settled. These cases proceed to an administrative hearing, and an administrative law judge will prepare a proposed decision, which includes a recommendation to uphold the discipline, modify the discipline, or dismiss the case entirely. When considering whether to adopt or reject a proposed decision, CBA members should review the factors to consider when deciding whether to adopt or not adopt a proposed decision section of attachment 1 with the item that is provided to you. These factors include determining if the evidence supports the legal conclusions, if the law and standards have been interpreted correctly, and if the witnesses are credible and if the penalty is appropriate to protect the public. This concludes my presentation of the enforcement process and the role of the CBA members. At this time, I'd like to turn it over to President Rosenbaum and would be happy to answer any questions members may have.
All right, thank you for that overview. Are there any questions that anyone has at this point? Okay, well, that's obviously timely since we have several of those today. All right, thank you. And then do you want to continue with the overview of the petition process?
Yes, this is also timely because we have several of these today as well.
That is true.
Okay. The purpose of this item is to provide the CBA with an overview of the petition process and the role of CBA members. And again, there's no action needed for this item. A person may seek reinstatement of their license when their license has been revoked or surrendered, or a reduction of penalty for those already placed on probation. A petition for reduction of penalty allows the petitioning licensee to request that certain terms of probation be reduced or removed, or that probation be terminated in its entirety. The petitioner bears the burden of proof by clear and convincing evidence that they are rehabilitated and safe to practice public accountancy. Moving on to the role of the CBA members. The CBA members' role includes serving as the decision makers at the conclusion of the hearing. In making a determination, CBA members should focus on the CBA's legislative mandate of consumer protection, which states that the protection of the public shall be the highest for the CBA in exercising its licensing, regulatory, and disciplinary functions. During the petition process, members may ask clarifying questions of the petitioner. The questions should focus on the petitioner's rehabilitative efforts to determine if they are rehabilitated and safe to practice public accountancy. Questions should not include personal questions that are not relevant to rehabilitation or questions that revisit the original case, except to evaluate subsequent rehabilitation. Members must carefully determine whether the petitioner has met the burden of proof by submitting clear and convincing evidence that demonstrates their rehabilitation efforts, competency, and fitness to safely practice public accountancy. And this rehabilitation criteria is provided in the materials as attachment 3. Members may consider only facts contained in the administrative record, and the CBA cannot reassess the CBA's initial disciplinary action as that case is final. When assessing the petitioner's rehabilitation, CBA members should evaluate facts on a case-by-case basis and in an objective manner. Consider any mitigating and aggravating factors, and be consistent and use the CBA's disciplinary guidelines if considering granting reinstatement with conditions. These are guidelines, and different facts may require different conditions for probation. After the hearing is complete, the administrative law judge will close the record and the CBA members will convene into closed session to deliberate and decide on the petition. The administrative law judge will prepare the written decision for the CBA's approval, and upon members' approval and signature by the CBA president, the decision is served via mail to the petitioner. This concludes my overview of the petition process and role of CBA members. At this time, I'd be happy to turn it over to President Rosenbaum and answer any questions members may have.
Okay, once again, thank you very much for that overview. Do we have any questions or comments by any of the board members? Do we have any public comment from those attending in Sacramento? Moderator, would you please open the lines to see if we have any public comment for those attending via WebEx?
Certainly. If anyone would like to make a comment on the presentations, you may look for the hand icon and click that once to raise your hand, or you may look for the question mark icon, click that, type the word comment, and click send. Each speaker will have 5 minutes with a 30-second warning. Are there any questions from the public? I do not see any requests for comment. Shall I close that feature?
Yes, please. Thank you.
You're welcome.
Right. 1 second while I get organized. Okay, so I guess we're now down to agenda item 12. Agenda item 12 is closing business. 12A is for agenda items for future California Board of Accountancy meetings. So leave it open to any of the board members. Do we have any specific agenda items that we'd like to put on the agenda for future meetings? Okay, seeing none, I'd like to open it up for public comment. Are there any members of the public in Sacramento that would like to add something for a future agenda item? Seeing none, moderator, can you open the lines to see if we have any public comment from those attending via WebEx?
Certainly. If anyone would like to suggest a comment for a future meeting, you may look for the hand icon and click that to raise your hand, or you may look for the question mark icon, click that, type the word comment into the text box and click send. Each speaker will have 5 minutes with a 30-second warning. And I do not see any requests for public comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Okay, so that concludes our agenda items for this morning. We have a 10 o'clock time certain beginning, so we'll take our morning break now and reconvene promptly at 10 a.m. Okay, it's now 10 o'clock, so we are going to resume our day today. We are now going to move on to agenda item 13, petition hearings, 13A, and the first one up is for David Chavez, CPA.
Ready? All right, we're on the record before the California Board of Accountancy in the matter of the petition for termination of probation of David Ray Chavez and Chavez Accountancy Corporation. This is board case number AC 202134, Office of Administrative Hearings, case number 2024051014. Mr. Chavez, my name is Matthew Block. I'm an administrative law judge with the Office of Administrative Hearings. To establish a quorum of the board, I would request that each member respond audibly when their name is called. Ms. Salazar,
Present.
Ms. Dong,
Present.
Mr. Rosenbaum, here. Ms. Tu,
Here.
Ms. Lotta,
Present.
Mr. Jacobson,
Here.
Ms. Batchelor,
Here.
Mr. Aguilera,
Present.
Ms. Thompson,
Here.
and Ms. Farrell Hines.
Mine's here.
Hines, okay, thank you. Yeah. All right, we have established that a quorum of the board is present. Mr. Chavez, the procedure that will follow this morning is Mr. Durkar with the Attorney General's office will present your petition to the board, give a brief overview of the case. Then you'll have the opportunity to testify under oath and to submit any documents that you wish to, subject to their admissibility. If you have any questions at any time, let me know. I can't give you legal advice, but I may be able to help you. I may be able to help explain why we're doing or saying certain things. Okay. So do you have any questions before we begin? No. All right. Mr. Durkar, I will turn it over to you.
Thank you, Your Honor. I appear on behalf of the people of the state of California by authority of Business and Professions Code, Section 5115, and Government Code, Section 11522, for this hearing on a petition for reduction of penalty by David Ray Chavez and Chavez Accountancy Corporation. So there are two petitioners. My role is to assist the board and Your Honor in fact-finding. This role is not adversarial, but is intended to protect the public health, safety, and welfare. I'm here to ensure that the board and Your Honor have all the information you need to make the reasoned decision. Turning now to the evidence, Your Honor, if that's all right.
All right.
The board members and petitioners have been provided with a copy of the same petition packet. The documents total 50 pages and are marked DRC-PET 001 through 50. The notice of hearing is at page 48. The petition itself, excuse me, is at pages 5 to 11. And I would like to mark the whole 50-page packet as Exhibit 1, and I offer it into evidence.
Mr. Chavez, any objection to that? All right. Exhibit 1 is admitted.
Your Honor, I'd now like to provide a summary of the case.
Please.
David Chavez received CPA certificate number 78026 in 1999. His business, Chavez Accountancy Corporation, received its corporate certificate in 2013. These licenses were revoked by the CBA with revocation stayed during 3 years of probation, which began on May 2nd, 2022. The petitioners stipulated to settle an accusation case. The underlying discipline arose from audit work. CBA's investigation was initiated by a 2018 complaint by a government employee. Due to the age of the matter involved in that complaint, the investigator obtained a single audit for the year ending June 30th, 2019, and deficiencies found in that audit led to a decision not to evaluate the older audits that were the subject of the complaint. Enough problems were found in the newer one to merit discipline. The facts and circumstances are summarized in Ms. O'Connor's memo at page 2 and in the accusation at page 32 of the packet. The accusation stated multiple causes for discipline, gross negligence and repeated acts of negligence, inadequate audit documentation, failure to issue a report conforming to professional standards, and willful violations. The petitioner's work on this audit contained a lot of errors, including multiple financial statement items incorrectly reported. There was a lack of appropriate disclosures and no substantive procedures for support of this audit, and that was a serious violation of professional standards. The list of problems in the audit was long. The disciplinary order from this board assessed costs of $6,500, which the petitioners have paid in full. The probation order requires participation in peer review and to supervise practice. Mr. Chavez, in his petition, claims that he and his firm ceased doing public accounting a year ago and that he now only does accounting for a charity. But he wants to retain his individual CPA license so that he can potentially teach accounting at a local community college. His only stated reason for why his petition should be granted is that he has not violated probation, that he's stuck to the term so far. He's submitted no letters of recommendation or documented any additional continuing education. And that concludes my summary of the case. Mr. Chavez has the burden of proof for the petitioners, and once his presentation is done, I will have some questions for him.
All right, thank you, Mr. Durgar. Mr. Chavez, do you wish to testify?
Yes.
All right, would you please raise your right hand, sir? Do you solemnly swear or affirm under penalty of perjury the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Because you're representing yourself, Mr. Chavez, what I'm going to do is allow you to testify freely in the narrative. When you're done, let me know. Mr. Durkar will likely have some questions for you, and then we'll open it up to questions from the board.
Okay, sounds good.
Okay.
Just kind of, I guess my background is I've been a CPA for obviously 20 plus years. My initial start was working for a small firm in the North Bay area. Then I actually ended up working for Deloitte & Touche, and then I merged on to a couple other firms. And roughly 15 years ago is when I started started my own firm, which I enjoyed, but one of the big needs I saw was doing work for nonprofits and the single audits. And knowing, sorry. Nonprofits and what was this? Well, it's a single audits for nonprofits, yeah, for nonprofits. And so, and it was one of those things that I know it's a high risk item. And, you know, I did get peer reviews through that whole time, and all my peer reviews were passed. We did have some deficiencies in a couple of them, but they were all passed. They were passed even subsequent to this issue that came up. So the oversight that was mandated, I abided by all the rules under that, submitted all the reports. But one thing I did notice is that because of, you know, this situation, it became almost impossible to get additional work as a CPA, meaning, you know, clients and what have you. And that's what made me decide to basically stop practicing, so to speak. But and unfortunately, when I work for a charity, and during this process, we were in sort of a negotiation with a union, and this particular thing came up as a negative to the organization. And so that's, you know, a big purpose here. It's not just, I'm not going to be practicing as a public accountant anymore, but it's also, you know, if I'm out doing work for a charity, having this out there as a, you know, a dark mark on your reputation can hurt and has hurt this particular charity. So I just, you know, my thing now is, even if I'm, you know, I continue on this process, all I have left is the quarterly reporting. And literally every time over the last year, is I'm just basically saying nothing. I haven't done any work. And it's really just really format at this point. And that's what it'll be over the next year. But again, it's more just expediting. I'm not doing this work and I'm also keeping a company open at my expense because it is a requirement. So I'd love to be able to close that as quickly as possible, close out the year and get that settled and because there's tax returns, there's all these things that need to be filed. And so my request is just to get this terminated, help me just move along and quote my, second, career, so to speak. I do love the work and I have been an adjunct instructor at American River College and I'd like to do that eventually. But again, this is sort of something that's going to be out there. And I know I wouldn't be able to do that with this on my record. That's it.
All right. Thank you for that. Mr. Durkar, questions?
Yes, thank you, Your Honor. Looking at page 19 of the packet, the probation terms, term number 11 is supervised practice. Who has been your practice monitor here during probation?
Justin Williams, and then Constance, I forget her last name. She unfortunately passed away, so I had to change CPAs during that. So.
How has that supervision process gone?
So again, I haven't done it in over a year because, well, let's put it this way. They haven't had to look at any work for over a year, but there were no issues noted in any of the jobs that they reviewed as submitted and reviewed by.
Did you ask either, well, one has passed away, but did you ask your current practice monitor to provide a letter of reference for you?
I didn't know if that was something I could have had. I mean, I think he probably would because he had been doing our peer reviews in years past. His comment on the last one during this supervising period. Oh, sorry. Was he was a bit, he said, you do really good work. I'm surprised that this had come up, but my guess is it was all positive, but I did not. I could probably ask.
What have you done since you were put on probation to rehabilitate yourself, to limit the chance of any future misconduct?
Most of it is just because the documentation standards were recently changed, and this, during this transition, it's really, it's one of those things where, let's say, I believe that I had sufficient documentation as my own CPA profession. It doesn't mean that somebody else coming in is going to agree with that, and I think that conforming during that transition time is a challenge. I mean, it's one of those things. I mean, I even wrote an article in the Cal CPA magazine about the challenges that a small firm has and how difficult it was going to be going forward. But as far as the CPE, I met all of the requirements for the CPE and honestly just continue to use outside resources to see what other firms are doing.
Thank you. Those are all the questions I have, Your Honor.
All right, thank you. We'll then turn it over to the board, starting with Ms. Salazar.
Thank you. The question that I have is in your statement, you mentioned that you worked for a charity. From your description, are you working in industry? What does working for a charity entail in terms
So
of
I'm working
services?
as their primary accountant at this point. I'm their CFO. And so unfortunately, and it's St. Hope, which is a pretty large charity in Sacramento, but there's also that sort of political element connected with them. And but it's been a good situation because of, I think, my history working with a lot of nonprofits and their need for someone in that position.
And then you mentioned you also have a business. So are you an employee of the charity you referenced, or are you
An employee.
Thank you. No further questions.
All right, thank you. Ms. Dong?
Thank you for testimony. You currently work with the charity that you mentioned. Did you ask them for a recommendation letter?
No, because I didn't know that that was something I could actually bring to this.
Did you ask for any recommendation letters on your behalf?
No.
In terms of CEs, have you completed any of the CE courses that were recommended?
All of them were completed within a timely manner, for sure. As
Okay.
noted, I think in the oversight, it's part of the petition, the quarterly reporting.
Okay. So just maybe a question to the attorney then. It says that Chavez and firm submitted no CE, page 3.
Yeah, I was referring to additional CE over and above what's required to renew the license and what was required by the terms of probation.
Okay. So no recommendation letters at all to, okay. Thank you. That'd be all.
Mr. Rosenbaum?
I have no,
Ms. Tu?
Thank you, Judge. You mentioned just now that the changes in accounting laws and so forth. And as a CPA, is it do you feel like it is your responsibility to understand the changes and learn about the changes and um, um, for your own profession?
Yeah, I think it's definitely, my responsibility, our responsibility as a practicing CPA. But one of the things that is going to change over the next year relates to outside review of work papers. And if you're a small firm, contracting someone outside to look at those work papers before you finalize, it's expensive. So if you're dealing with these margins that are a challenge as it is to be competitive, plus your CPE requirements, plus everything else, that's why I said as a small firm, it is going to be a challenge because there are these different, things you have to jump through.
Ms. Lata?
No questions, Your Honor.
Mr. Jacobson?
Thank you. Does Jason supervise or monitor in any way your work at the charity?
No.
Why?
It's not part of the requirements of my CPA probation.
It seems like when I looked at it, you had to have supervision of some sort for accounting work, and this. Well, let me ask you this: what do you do for the City of Hope?
So I'm an internal accountant. It's not public accounting where I'm actually, doing an auditing. So the way that the supervision worked was if I was to do any kind of report issuances. So if I, audited, reviewed, compiled financials, that would be subject to this requirement. This is basically, I'm not going to say completely different, but definitely different in that I'm on the inside doing accounting and reporting that part. I'm not auditing, I'm not compiling anything of that nature. And that's not part of like I said, this oversight, so to speak. And it is definitely different.
Thank you very much.
Ms. Batchelor?
Questions.
Mr. Aguilera?
no questions.
Ms. Thompson?
No questions.
Ms. Hines?
No questions.
Mr. Durkar, any further questions?
No, Your Honor.
Mr. Chavez, I will turn it back to you. Is there anything else you would like the board to know in terms of your rehabilitation?
I would just like, again, one of those things on my side is I just want to kind of move into the next chapter. I've loved being a CPA. I love the profession. And I just would love to get this settled as quickly as possible. And but if I didn't realize getting some recommendation was possible, I knew I could get them if needed. But I don't know if that's something that can be submitted subsequently or what have you, but I do appreciate your time and consideration.
All right. Well, thank you for that. So, Mr. Chavez, the board will go into closed session at the end of the day today to deliberate on your petition. You won't be notified of the result today, but you'll be notified of the decision in the mail at a future date, okay? So thank you for your testimony. I appreciate that. I know the board does as well. With that, the matter is submitted, the record is closed, and as for this petition, we are off the record. Thank you, sir. Good luck to you. Mr. Bernard, I have 1021. All right, thank you. And Mr. Durkar, which petition do you wish to take up next? All right, Mr. Harmon, if you can come forward. Right. All right, we're on record before the California Board of Accountancy in the matter of the petition for reinstatement of Larry Wayne Harmon. This is board case number SI 202440. Office of Administrative Hearings, case number 2024060079. To establish a quorum of the board for the record, if the board members would please respond audibly when I call their name. Ms. Salazar?
Present.
Ms. Dong?
Present.
Mr. Rosenbaum?
Here.
Ms. Tu?
Here.
Ms. Lotta?
Present.
Mr. Jacobson?
Here.
Ms. Batchelor?
Here.
Mr. Aguilera? Ms. Thompson?
Here.
Ms. Hines? All right, quorum of the board is present. All right, Mr. Harmon, you are representing yourself, correct?
Yes, sir.
All right, now I know you sat through the previous hearing. As you can see, the procedure is pretty straightforward. Mr. Durkar will present your petition, give an overview of the case. You'll then have the opportunity to make a presentation on your own behalf, and then we'll open it up to questions from Mr. Durkar or the board. The board is particularly concerned with the rehabilitative efforts you've made since the disciplinary action. And like I said in the last hearing, if you have any questions during the hearing, let me know. Do you have any questions before we start?
I do not, sir.
All right. Mr. Durkar?
Thank you, Your Honor. I appear on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 for this hearing on the petition for reinstatement by Larry Wayne Harmon. My role is to assist the board members and Your Honor in fact-finding. This role is not adversarial, but is intended to protect the public health, safety, and welfare. I'm here to ensure the board and Your Honor have all the information you need to make a reasoned decision. Your Honor, may I introduce the evidence?
Please.
The board members, Your Honor, and the petitioner have all been provided with a copy of the same petition packet. The documents total 73 pages and are marked LWH-PET 001 through 73. The notice of hearing is at pages 71 to 72. The petition form itself is at pages 5 to 17, and Mr. Harmon's attachments continue up to page 46. I would like to mark the whole packet as exhibit number 1, and I offer it into evidence.
Any objection, Mr. Harmon?
No objection, sir.
All right, thank you. Exhibit 1 is admitted.
Your Honor, I'd like to provide a summary of the case.
Please.
Mr. Harmon received his CPA certificate in 2003. His license was revoked in 2013 when this board accepted his stipulated surrender. This is his second petition for reinstatement. The prior one was denied in 2018. The underlying discipline arose from a felony conviction. The facts and circumstances are summarized in Ms. O'Connor's memo at page 3, and in the accusation starting at page 66. The accusation charged Mr. Harmon with fiscal dishonesty, and knowingly preparing fraudulent information. The accusation alleged that in 2010, Mr. Harmon acted through his firm, Larry Harmon and Associates, to submit a fraudulent claim to the California Board of Equalization seeking a $4.6 million refund of sales taxes on allegedly defaulted auto loans. When a consumer defaults on an auto loan, the lender is entitled to a refund from the Board of Equalization of the sales tax that the lender paid. The refund form that Mr. Harmon submitted was fraudulent and was filed on behalf of a fictitious company, which Mr. Harmon alleged had provided vehicle financing to over 1,800 automotive dealers. Mr. Harmon submitted fraudulent documents claiming that this fictional company had assigned its rights to the sales tax refunds to Larry Harmon and Associates. Mr. Harmon's license surrender admitted the truth of each and every charge and allegation in the accusation. That's at page 59 of the packet. In the petition that's before us, Mr. Harmon explains at page 13 why he believes the petition should be granted. He says that he believes in second chances. He notes that he voluntarily surrendered his license. The criminal conviction, he says, is the only time that he's ever been in trouble. It has been 13 years since his arrest and 10 years since his release from incarceration. And he got his criminal record expunged. Mr. Harmon explains that he wants his license reinstated so that he can then request to have his license retired and use the title or have the title CPA retired. He does not plan on practicing public accounting again. Business and Professions Code, section 5070.1, subdivision C, it says that the board shall deny an application for retired status if the permit is subject to a disciplinary order, is revoked, or is otherwise restricted. So he wouldn't be able to attain this CPA retired status, which he seeks, unless his license is first reinstated. I would also like to note, though, that even if Mr. Harmon's license is reinstated at this time, he isn't yet eligible for CPA retired status because Board Rule 15.1 subdivision B says that to qualify for retired status, a person has to have held a license as a CPA for 20 years, with at least 5 of those years being in California. Now, Mr. Harmon was first licensed in Washington back in 1994. He retired that license in 2007, and his California surrender was effective November 2013. So it would appear that he'd need to be reinstated for a period of at least 13 months in order to qualify for the retired status, which he says that he wants. Also, I'll point to a couple other things in the packet. At page 65 is a Sacramento County Superior Court order from 2018, which set aside Mr. Harmon's conviction and entered a plea of not guilty to all charges. It notes that he served 16 months in county jail after his conviction. Also in the packet is some negative license history from the state of Washington. Mr. Harmon obtained a CPA license from that state, as I noted, in 1994, retired it in 2007, and in 2018, he submitted an application to renew it, but did not disclose his disciplinary history with the CBA as required. His application was denied on that basis. Mr. Harmon then sought a hearing on that denial, but didn't appear for it was a preliminary hearing. It wasn't the evidentiary hearing on the case, but for his failure to appear at that particular hearing, scheduled appearance, the Washington board's denial of his application was affirmed for his failure to participate in the case. That's at pages 48 to 55 of the packet. Pages 21 to 37 document 120 hours of CE that he earned in 2018. All 120 hours, per the certificates at least, were reported to have been earned in 5 days from January 30th to February 2nd, 2018. From the timing of it, it would appear that the CE was taken in support of his application to renew the Washington license. It does not appear that Mr. Harmon has taken any additional continuing education since 2018. He has submitted no letters of recommendation, and that concludes my summary of the case. Mr. Harmon will have the burden of proof, and once his presentation is done, I'll have some questions for him.
Mr. Harmon, do you intend to testify?
Yes, sir.
Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Thank you, Mr. Harmon. Similar to the last petition, Mr. Harmon, I'm going to allow you to testify freely in the narrative. When you're done, let me know. Mr. Durkar and the board will have some questions for you, okay?
Okay. First, I'd like to thank everyone for allowing me to be here. And I'd also like to apologize at the same time for you having to be here and listen to me. As you can imagine, this was probably one of the most detrimental things in my life. And my sole reason for being here today was not because I want to practice public accounting, but it's a part of the journey that since my arrest in 2013 that I have to forgive myself. I have to move on. And, you know, whether you reinstate my license or not reinstate my license is not going to change my life, other than the fact that I worked my butt off my entire life. I kept my nose clean my entire life. I was very involved philanthropically in the greater Sacramento region. I now live in Bozeman, Montana, which is my home state. But all I can do is say I apologize to you and apologize to my God and my family, and I leave the decision in your hands freely, and no matter what decision you make, I thank you for allowing me to be here. As how do I pronounce your last name? Dakar, as Mr. Dakar said, my whole sole purpose for this application was for the mere fact of being able to use the words CPA retired, and that really means more than anything in the world to me. You know, as we all know, CPA is not an easy exam to pass, especially from an old guy like me that took it under the standard in Montana, where you had to sit for all 4 parts and condition 2 parts and pass 2 parts. So I'm here to answer any and every question. One thing I will share with you, I wear hearing aids, and I as you saw on my phone, I turned them way up. So hopefully I don't have to ask anyone to, repeat questions too many times. So.
All right. Thank you, Mr. Harmon. Mr. Durkar.
Mr. Harmon, could you please give us a summary of your accounting career before you surrendered your license?
So my career started at this now defunct firm called Touche Ross, one of the big 8s. I started that in 1988 in the Oakland, California office. And in the fall of 1989, Touche Ross merged with Deloitte Haskins and Sells to then be called Deloitte and Touche. In 1988, our classes in the firm of Touche Ross, it was their first year that they allowed undergrad students to be admitted directly into tax practice, as opposed to start an audit and then move into the tax practice. So we were kind of the experimental guinea pigs, of which I was very thankful for, because I'm not a big fan of accounting, to be honest with you. I hate debits and credits, but I love tax. I love consulting. I love mergers and acquisitions and the things that I'm very good at. So I was in the compliance section doing tax returns, so on and so forth. I did not care for that. So at that point in time, Deloitte and Touche did not really have I saw a niche, and that's how my brain works, is I kind of see into the future. I saw a niche in the need for consulting in what is called the SALT area, state and local tax. So instead of learning one tax code, your federal tax code, I had to learn 50 tax codes and know all the state laws. And so I left and I went to what was then Price Waterhouse for 2 years, and worked in their firm. During this time, I got married and had my first child. As you know, the big firms are a grind. I spent 2 years there in the state and local tax consulting arena. Left there when my wife and I found out that she was pregnant with our second child, and went to work for an Chiron Corporation in Emeryville, California, which was a biotech company that no longer exists. I was the head of their state and local tax program for 4 years. I actually had the infamous case here in the state of California where I won on apportionment methodology. If you remember the old method, the apportionment methodology was, salaries, equipment, the three-pronged test, and what I did is I said, the technology companies are kind of getting their unfair advantage here. We must include intellectual property, so not just fixed asset must. So we won that case, and so that was kind of a fun thing. So during my time at Chiron, I also flew across the country when we established new facilities across the country, backup facilities, because we were in earthquake zones. We had to have, because FDA required you to have backup facilities and redundant facilities, not only from your computer system, but also from the ability to scale up and manufacture immediately on your patented product. So I did that, and it was about 1994, 95. Deloitte it was still Deloitte and Touche at the time, but they made a real big push because less and less people were going into the accounting profession. They made a big push to go back and hire some of their highly regarded alumni. So they hired me. They asked me to go down to the Los Angeles office, which was their tax think tank. Any tax products, if you will, that came out of the firm were either through LA office or Washington national office. I was part of their national, state, and local tax reorganization team, focusing on tearing companies apart and putting them back together for the purpose of tax minimization strategies, legally speaking, by the way. And then also did mergers and acquisitions. In 1999, that was actually the fall of 1998. My packet was submitted for partnership at Deloitte and Touche, and we had what they called charm school, they called it basically. And so we all went down to Orlando, you submit your package, so on and so forth. And at one point in time, for the petition, I literally represented every auto finance company or bank in the country that did auto loans. So I was a leading expert in the area myself, and a lawyer out of Jacksonville, Florida, Pete Larson. So during Pete Larson, Ackerman Senefit was the name of the firm. But anyway, as part of your submission for partner package, you had to get a letter of recommendation from your top 5 billing clients. And my top billing client was Chrysler Financial at the time. And Rick Sheeran, the head of tax, not only was he a good client, but we became friends over the years. And when I was in Detroit at the time, my package arrived in his office, and he told me, Larry, he goes, I have to fill this out for you. He goes, I'm not supposed to give you a copy, but I am going to give you a copy. And he said, I just want to let you know that if you ever decide to leave Deloitte, because both him and he had just left, Ernst & Young's a couple of years prior, and his wife was still at Ernst & Young, but just wanted to solidify that if I had the notion to leave Deloitte, that he would follow me wherever I went, because he trusted in my ability to do the project for him. So when Deloitte asked me to wait a year in a partnership, I left, in fact, February 11th, 1999 is my Independence Day. That is the day I left the big accounting firms and started working for myself. Larry Harmon Associates was formed on that day out of the kitchen in Fullerton, California, where I lived. Had no money in the bank, didn't know how I was going to make it, support 2 kids, but I did. And then did that and grew a practice. We moved to Granite Bay in would have been June of 1999. Continued my practice here. At one point in time, I had 25 employees. I then took on a partner, Mr. Frank Castillo, who we then became known as Harmon Castillo. And that takes us up to the point in time of the tragedy. And after that, I And after that, and since then, I have not practiced accounting per se. I still get questions from friends and unfortunately do a lot of free work, but that's my history.
What work have you been doing since you surrendered your CPA license?
In 2015, 2016, my mother was diagnosed with Parkinson's. Fortunately, I had made enough money that I could retire. But my wife and I decided, my mom got really, really sick from the pharma she was taking for her Parkinson's. And as you could imagine, I probably love my mom more than any woman in this life. My wife would probably smack me in the head right now if she heard me say that, but I think she'd understand why. When you watch your mom get to a near death status, you do anything that you can to bring that back. So we invested a bunch of money along with some partners and did a lot of research in CBD, and which actually saved my mother's life. So predominantly been doing that. Every now and again I'll pick up a consulting project, but that's what I've been doing. And like I said in my earlier testimony, sir, is I am not seeking reinstatement to go out and practice as a CPA again. I'm doing it for myself and for my family.
Your CE that you submitted with a petition, it was taken back in 2018, and you are seeking reinstatement, which would give you the ability to practice. Have you done anything recently to prepare yourself for practice as an accountant?
Yes and no. I would say the preparedness is I am always a forever lifetime student. I constantly pay attention to the tax code. I read every day. I spend a lot of time on the computer, so on and so forth. I'm fortunate that my first child followed in my footsteps. It was going to be, I started out was going to be a civil engineer and wound up an accountant. My daughter went to my alma mater, Montana State University, to be on a prestigious medical scholarship, and wound up an accountant. So between my reading and our interactions as father and daughter, it's fun because she bounces a lot. There's still a lot of good knowledge in this brain, and she bounces a lot of stuff off me. And unfortunately, I don't know why, but I'm still a tax code head. And it's funny how these kids I call them kids there. She's 33, but these kids just don't learn the tax code today like we had to do back in the day. So would I consider myself an expert in the current tax code? No. If I were to give my proficiency in tax on a scale of 1 to 10, I'd probably give myself about an 8, 8.5.
In 2018, the CE certificates that you provided indicate that you earned 120 hours in just 5 days. How did you do that?
Well, as we know, there's this thing called online CPE, and it's probably some of the easiest stuff you'll ever do in your life. I took all of my credits, basically almost not sleeping, from CPE Depot, and their platform is such that you can do it one of two ways. You can go through all the material and then take the test, or you can just start taking the test and everything you don't know. It kind of points you back to the area of the material that you have to do. So those 120 hours were honestly and legitimately done. I followed all the criteria. I took the test and I passed it and got the requisite certificates.
Mr. Harmon, could you please describe for us in your own words the criminal conduct that you engaged in back in 2010?
That's a tough one in my own words. Essentially, like I said, I was the leading expert in this arena in sales tax. Myself and the law firm, Ackerman Senefit, Pete Larson, we sued 32 states. They sued on behalf of auto finance clients. Obviously, the standard case here now in California is called the WFS case. We won that case in, I think, 2001, maybe it was. But to go back to what happened, I'm going to take full responsibility. I kind of got coerced into doing this work, compiling information that wasn't accurate, and submitted false refund claims on behalf of a fictitious company. I will forever take the blame. The buck stops here, and it was something very, very bad that I did, and for that I apologize. And I can assure you that in the event I'm so lucky to have my license reinstated for at least 13 months, that I will adhere to any standard that you want to hold me to. Because I tell you right now, I live my life. I cross every T and I dot every I at least 10 times. And I, it's been a tough road. But like I said, no matter what happens today, I had to be here, and I thank you for letting me be here.
Mr. Harmon, on that last point that you made about, you said that you wouldn't do anything illegal again, but why should this board, can you elaborate about why you think this board should trust you not to do something illegal or unethical again?
Well, I think the word that you guys like to use is rehabilitation. I would like to use a word even stronger than that. I'm just smarter than that. This is about a second chance that a lot of people don't get in life. And that's what it is. And I can assure you I'm not going to screw up the second chance. And like I said, when we had our conversation the other day and you informed me that I couldn't get the status of CPA retired currently, and that I had to do 13 months. I mean, 13 months of an active CPA, that I'm fine with that and to do whatever you want. And if, whatever program that, if you were to grant my license back, whatever program you put before me, as long as it's reasonable and fair on my part, I'm very open to that. So.
Your Honor, those are all the questions I have.
Thank you, Mr. Durkar. Ms. Salazar.
Thank you for your testimony. I think the question I have is, could you tell me a little bit more about your current work? In your packet, you say you want to continue working for yourself. You mentioned you're an entrepreneur and that you consult. So could you just elaborate a little bit more what your work and where that work is? Where is your client base?
So, I mean, most of that, ma'am, comes from, like I said, people that are close to me, people that know me. Whether it's, hey, I'll get a question. Hey, I'll tell you a current one is my brother-in-law died, cocaine overdose accidentally, 55 years old, and has left my wife's sister in shambles. They don't know how to, they just did this acquisition and we're trying to unwind it, so on and so forth. So stuff like that, I don't get paid for it, ma'am. I don't charge a fee for it. Same thing in the CBD world. I've become kind of a leading expert in, believe it or not, in nanotechnology and the impact and the bioavailability on that stuff. So I do work in that arena too. But honestly, mostly I sit at home, take care of my dog, hang out. My wife is a practice manager in the healthcare business. We are actually she's just notified me today she's resigning in 3 weeks, so we'll be moving down to a little tiny town in Texas, and hopefully playing a lot more golf and doing some more fun things in life together. And we're finally empty nesters, and we're looking forward to that. So
Thank you.
Ms. Dong?
Thank you so much for your testimony. So you mentioned that your current work is, in your petition, you mentioned you're an entrepreneur. But in your testimony, you mentioned that you currently work for people who know you very well, for instance, extended family members. Did you ask them for letters of recommendation on your behalf?
I did not.
Okay. In terms of your CEs, by your own admission, the 120 hours were, done in 5 days. These are pretty easy. You click through. And you have not submitted any other CEs in the past 6 years at all since you completed those online programs?
I have not. In fact, I will be honest with you. It wasn't until about January of 2024. I had no intention to ever come and be sitting here before you today. And for some reason, maybe the blessing of God, I made a decision to tell my wife 2024 is going to be the year that I put this behind me. And this is a part of it.
And just a question for councils. So the petitioner is asking to reinstate his license to surrender it for retirement. There's nothing that prevents him from practicing if it is reinstated. Is that correct?
Yeah, that's my understanding is that he would be able to practice.
Okay, thank you.
Mr. Rosenbaum,
I have no further questions, Your Honor.
Ms. Tu,
Questions?
Ms. Lotta,
No questions.
Mr. Jacobson,
Your Honor, I have no questions.
Ms. Batchelor.
Yes, I have a question. When you were describing what led into the incidents that happened, you say you were coerced into it. Could you explain that, please?
Without getting anybody else in trouble, there was a member of the board at the time, an auditor, that talked about, hey, all these election statements, so on and so forth. And, that's kind of what sprung the idea in my mind and why I did it. Ma'am, honestly, I can't even tell you why to this day. I just know it's the most embarrassing part of my life. And it's just need to get past this. So.
Mr. Aguilar.
Thank you for being here. Appreciate your time and effort, and I commend you. I am wondering about the continuing education effort. Do you consider your approach ethical?
I do, sir, because these CPE companies online are licensed by every individual state, every board of accountancy. The programs are reviewed by the boards, and therefore, if they're offered for a fee, then they've been vetted by all the states. And if somebody like myself, who has an above average IQ, can do a 8-hour job in 4 hours, I mean, that's pretty common in today's world.
I think that in order to be an active licensee again, you'll have to complete some continuing education. And I'll tell you what my worry is, and I'd like your response. My worry is that you will shortcut the process again just to get the hours without the benefit of the education.
I wouldn't call it a shortcut, sir. I guess what I struggle with on that question a little bit is, once again, I'll go to the fact of the individual, because I know several people like myself that can do an 8-hour job in a 4-hour day, or an 8-hour job in 4 hours. Why should I be penalized for that and not be allowed to take a class that I can complete my hours that are, it's not about a shortcut, sir. It's just about intelligence, I think. And I think I'm sorry if you're taking that the wrong way, because that's not the way it's meant to be.
And then I just want to see if I can pinpoint the motive here for reinstating or ultimately obtaining the retired CPA status. And I can't think of a better way to say this, so excuse me. Is it for vanity purposes or some other purpose? I'm trying to figure out how will you, once you have that designation and are allowed to use it, how will you use it?
Just to be able to put that after my name again would mean the world to me. And so I guess to your answer, yeah, there is vanity to it. Yes, sir. I mean, for all my years, having those letters after your name is one of the most proud things ever. It's an accomplishment, just like ESQ, just like my daughter who's a doctor. I mean, you put forth the effort in your studies and your tests and your so forth, and you did not take that away from me. None of you guys took that away from me. I took it away from myself.
So I understand.
Ms. Thompson.
What is the current status of your license in Washington State?
So I'm glad you asked that question, because to elaborate on the packet is, I was supposed to go to Olympia for a hearing, and I'll be honest with you, in 2018, I was still in a very, very heavy funk, personally. And I will not lie to you, and I will not sit here and lie to you and tell you that at some point in time I was suicidal. I didn't know if I wanted to go on living life, and so I purposely chose not to go to Olympia, and that was really not smart on my part. So Washington license will forever not be active as far, I don't, this was really my practicing license for the last part of my career. And I don't anticipate ever applying to any other state for a license because I don't intend to practice.
Ms. Hines?
Thank you for coming. I have no further questions.
Mr. Durkar, any further questions?
No, Your Honor.
So, Mr. Harmon, similar to the last hearing, the board will go into closed session to deliberate on your petition later today. You'll be notified of that decision at a date in the future. Is there anything further you would like to say before we conclude?
I'd just like to say one more thing because of the whole issue of the CPE and the ability to take 120 hours in 5 days. Once again, I'll reiterate that if you want to put together a program for me that I need to adhere to, I think that's fair. If you say we want you to take these classes from this individual, and that's 40 hours, and obviously the ethics exam is a part of that, I'm not opposed to it. I want you to know that, please. And then in closing, I just once again want to thank everybody, and at the same time apologize to everybody.
All right. Thank you for that, sir. With that, the matter is submitted, the record is closed, and we are off the record. Good luck to you, sir.
Yes, sure. Let's take a 5-minute break.
29, and I have 10:56.
We're back at 11:05.
Thank you.
Okay, we're back in session and ready for the next hearing.
All right, we're on record before the California Board of Accountancy in the matter of the petition for reinstatement of Subramaniam Ramanan, board case number SI 2024-41, Office of Administrative Hearings, case number 2024-060-081. To establish a quorum of the board, I would request that all members respond audibly when they hear their name. Ms. Salazar,
Present.
Ms. Dong,
Present.
Mr. Rosenbaum, Ms. Tu,
Here.
Ms. Lotta,
Present.
Mr. Jacobson,
Here.
Ms. Batchelor,
Here.
Mr. Aguilera,
Present.
Ms. Thompson,
Here.
Ms. Hines.
Here.
All right. Quorum of the board is present. May I have the appearances of council, please?
Neginyamini on behalf of Mr. Walton. Can everyone hear me okay, or should I speak into the microphone? Okay. Okay, better now? Okay, wonderful, thank you.
And Mr. Durkar again is here. Mr. Durkar?
Yes, Deputy Attorney General Ted Durkar on behalf of the people.
All right, thank you. While we were off record, there was a request by Ms. Yini to make a opening statement. Mr. Durkar, do you wish to make one?
I don't have an opening statement, but I don't object to opening statement on behalf of petitioners.
Okay, please.
Thank you, good morning, everyone. I wanted to apprise Your Honor and the board members that since the submission of the personal statement and supporting documents by Mr. Ramanan, the focus and attention of this hearing from our point of view has changed. Whereas previously it appeared from the documents submitted that some of the factual findings by the ALJ were going to be questioned at this hearing. That's not going to be the case. We're not going to revisit or relitigate any, that is my client and I. I mean, you're welcome to ask questions if you deem it those questions necessary, but my client and I are not going to revisit any factual findings previously made by an ALJ pursuant to an administrative law hearing that took place. The focus from our point of view will be exclusively on rehabilitation. That is what Mr. Ramanan has done since the findings made by the ALJ in order to bring himself to a position of rehabilitation and accountability. And that would be the focus. Thank you.
Thank you. Mr. Durkar, do you wish to make or to present your case?
Yes, Your Honor.
Okay.
So just for the record, I appear on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 on this hearing for petition for reinstatement by two petitioners, Subramaniam Esawara Ramanan and Nika Accountancy Corporation, his accounting business. My role is to assist the board members and Your Honor in fact-finding. That role isn't adversarial, but is intended to protect the public health, safety, and welfare. First, I would like to introduce the documents, Your Honor.
All right.
And I am going to break them up into separate exhibits. The board members, the petitioner and Your Honor, have been provided with a copy of the same petition packet. There were a couple of sets that went out, but all told, there should be 228 pages in your packet marked SER-PET 001 through 228. And I'm going to break this packet into multiple exhibits. For the first exhibit, I would include matters at the front of the packet, including the summary memo from the enforcement chief, Ms. O'Connor, at pages 1 to 4. The petition itself is at pages 8 to 16. Mr. Ramanan's lengthy statement in support of the petition is at pages 16 to 27. His registered tax preparer certificate is at page 28. CE completion certificates are at pages 29 to 43. So what I would ask is to mark pages 1 through 43 as Exhibit 1, and I offer them into evidence.
Any objection?
No, Your Honor.
Exhibit 1 is admitted.
Mr. Ramanan submitted other materials that I would agree to admit into evidence as administrative hearsay, including a psychological evaluation report at pages 155 to 162, reference letters from a number of individuals at pages 163 to 175, professional certificates and documents about past jobs and education are at pages 176 to 191. So I would like to mark pages 155 to 191 as Exhibit 2 and offer them into evidence as administrative hearsay.
Any objection?
No objection, Your Honor.
Exhibit 2 is admitted.
Next are some jurisdictional documents, including the notice of hearing at pages 151 to 152, Mr. Ramanan's reply at pages 153 and 154, and his certified license histories at pages, well, I say his certified license histories, both petitioners, his and Nika Accountancy Corporation's license histories at pages 147 to 150. So I would ask that pages 147 to 154 be marked as Exhibit 3, and I offer them into evidence.
147 to 154.
Yes.
Any objection?
No, Your Honor.
Exhibit 3 is admitted.
Next, I'll identify the documents that constitute the board's disciplinary orders against the petitioners. There is the board's decision and order after hearing with the attached accusation, and that's at pages 115 to 146. And that decision and order is dated May 29th, 2012. Then there is the board's order lifting stay and imposing penalty after the Supreme Court's decision. That's at pages 75 to 76. That is dated November 26, 2019, 7 years later. The 2012 revocation order had been stayed and didn't take effect until 2019. So I'd ask to mark pages 75 and 76 and 115 to 146 as Exhibit 4, and I offer them into evidence.
Any objection?
No, Your Honor.
Exhibit 4 is admitted.
And then lastly, there are documents in the packet that consist of decisions from petitioners' judicial challenge to the board's decision and order, starting with the Superior Court Statement of Decision and Judgment, which denied the petitioner's mandamus challenge of the board decision. So that's at the Superior Court level, first level of review, and that's pages 193 to 228. It is dated October 14th, 2014. Next is the decision by the Court of Appeal denying petitioner's appeal of that Superior Court decision. That's at pages 77 to 114. That appellate decision is dated August 27th, 2019. Finally, we have the Supreme Court's decision. It's a one-page order denying their petition for California Supreme Court review. That's at page 192, and it's dated November 13th, 2019. So I would ask to mark those three documents, which are pages 77 to 114, 192 to 228, as Exhibit 5, and I offer them into evidence.
Ms. Yamini, any objection?
I do, Your Honor. In light of the fact that the focus of these proceedings is entirely on rehabilitation, I would object on the basis of relevance with respect to the decisions from Mr. Ramanan's judicial challenge. To the extent that Your Honor would deem them admissible, I would ask that you give it the proper weight that it deserves. Thank you.
Understood. I would overrule the objection. The documents will be admitted.
Thank you, Your Honor.
Finally, I need to address pages 44 to 73. That is a set of documents that Mr. Ramanan submitted. Those documents would serve to relitigate issues that were decided by the board and the courts. And I've spoken with his counsel, and I believe that they should be withdrawn. I don't believe there's any objection to that. So I would ask that pages 44 to 73 be excluded from the record of this hearing, not admitted into evidence.
Ms. Yamini?
No objection, Your Honor.
Right. Pages 44 through 73 are withdrawn.
All right, and now, Your Honor, I'd like to provide a summary of the case.
Please.
Mr. Ramanan received his CPA certificate in California in 2002. Prior to that, he had decades of practice in other nations, including Sri Lanka, New Zealand, and in Africa and Zambia, I believe. His accounting business, Nika Accountancy Corporation, got its corporate certificate in 2004, 2 years later after he got his CPA certificate. Both licenses were revoked by the CBA effective June 28, 2012, but that revocation was stayed by judicial order while the petitioners challenged the CBA's decision in Superior Court, then on appeal, and that process of judicial review lasted 7 whole years from 2012 to 2019, and they were able to continue practicing without, because the disciplinary order was stayed. This is their first petition for reinstatement since their licenses were finally revoked in November 2019, once that stay was dissolved. The underlying discipline arose from audit work and dishonesty which followed. The facts and circumstances are summarized in Ms. O'Connor's memo at page 2 and in the accusation spanning pages 139 to 146 of your packet. They were disciplined for audit failures and for Mr. Ramanan's dishonesty in the enforcement process that followed. The accusation stated 8 causes for discipline covering the following misconduct: failure to maintain independence from the audit client in violation of GAS and GAP, because one of Mr. Ramanan's employees made management decisions and served in a consulting role in the capacity of a chief financial officer for the audit client. Then there was gross negligence in the performance of the audit for fiscal years ending in 2003 and 2004, including violations in terms of audit planning and documentation, repeated acts of negligence in planning, performance, and documentation of these audits, violation of professional standards, use of the name NICA Accountancy Corporation, which had not yet been registered with the CBA, and dishonesty for Mr. Ramanan's dishonest responses at an investigative hearing that was conducted during the investigation, and submission of a doctored set of audit documents and testimony at the administrative hearing that was found to be untruthful. The board's decision sustained all of these causes for discipline. All of these causes for discipline were also sustained in the review by the Superior Court and the Court of Appeal. The administrative decision, the proposed decision that was adopted by this board, stated that the audit failings alone would normally be cause for license probation, but Mr. Ramanan's dishonesty during the investigation and at the hearing made revocation the appropriate discipline. And for that, I look to page 130, paragraph 10 in the packet. The findings about Mr. Ramanan's dishonesty span 5 whole pages in the board's decision from 120 to 124 in your packet. He gave conflicting and dishonest testimony about a number of matters, including the role that his employee played in management consulting for the audit client, SISAT, which is what created the independence violation. And notably, the decision imposed costs, very significant costs of $141,885 to be paid upon any petition for reinstatement. The costs were very high due to a lengthy investigation process and a very long hearing that spanned 21 days, I believe. The administrative hearing was quite long. And it took up most of 2011. I think it started in January or February of 2011. There would be breaks, and then it wasn't finally wrapped up until November 2011. These costs are broken down between investigation and legal costs at page 130 of your packet and paragraph 17, if you wish to look. My understanding is that the petitioners have not paid any of these costs yet. At page 10 of the packet in the petition form, Mr. Ramanan stated the reason for disciplinary action was events that, quote, allegedly happened, unquote, in 2003 and 2004. He wrote that the complaint to the board originated from disgruntled employees, and he attributes the result of the hearing to the passage of time, biased witnesses, and legal errors by attorneys. Mr. Ramanan explains at page 13 why he believes his petition should be granted and states in relevant part that the complaints were by the complaints received by CBA were from disgruntled employees, that the attorneys involved, his own and the Deputy Attorney General who prosecuted the case, have blame. He notes the passage of time and says only one audit was involved, but it was for 2 years, and says that the public wasn't harmed. He does not address the dishonesty that was found in the decision, and that those dishonest acts span the time frame of 2008 to 2011. He attached a long biographical statement, which is pages 16 to 27. And I understand that the focus of the hearing is probably not going to be on that document or the matters argued in it, but a lot of it is devoted to rehashing matters that the board already decided. On page 22 of that personal statement, he explains in some detail why he thinks he is rehabilitated. I don't follow it entirely, but there's a passage that I'd like to read from the 4th paragraph. This is on page 22. He wrote, although many of the problems were beyond my control and awareness, I accept responsibility for the occurrences. Looking back, I realized that these issues might have been prevented or managed if I had been more attentive and cautious during my acquisition of Alan R. David's practice. He's referring to acquisition of an accounting business from another CPA. Having previously worked for the Big Four firms, I was unfamiliar with the potential challenges of purchasing a small CPA practice, and I regret my lack of foresight. My experience as an immigrant also played a role in my misunderstanding of the local system and the countries where I've lived, including Sri Lanka, UK, Zambia, and New Zealand. There is no customary practice of investigating accountants. In those places, accountants are regarded with significant respect and trust, a stark contrast to the treatment I received at the ALJ hearing. The offensive behavior disguised as questioning to which my wife and I were subjected was shocking. This is in his statement of why he is rehabilitated. I'd also like to note mitigating factors that he states on page 26. Among the mitigating factors that he notes are number 4, implementing corrective actions. He says that he made changes and corrective actions, including no longer having employees working as consultants offsite and using computer servers with antivirus and other security measures and nightly backups. Further down the page, he writes that starting in 2002, I may have failed to manage my employees properly. However, I feel that this failure is not a reflection of my ability to carry on as a certified public accountant. At pages 163 to 175, I believe, are a number of recommendation letters. I'll touch on some of them. At pages 163 to 164 is a 2021 letter from a client. The client writes that he's very pleased with the petitioner's services and says that Mr. Ramanan told him of unwarranted complaints to the CBA. This client's letter details excuses for the result of the disciplinary case and even Mr. Ramanan's grievances regarding the Superior Court judge who decided the mandamus case that challenged the board's decision. There is no reference in this letter to any rehabilitation, but there is considerable detail of Mr. Ramanan's claims of innocence of any wrongdoing. At pages 165 to 166 is a 2021 letter from another client. It explains that Mr. Ramanan told this client how he lost his license due to circumstances beyond his control, and details Mr. Ramanan's grievances against attorneys and the judge who were involved. At pages 167 to 169 is a reference letter and email form from an accountant dated in 2020. This accountant's known him since the 1980s, known Mr. Ramanan since the 1980s, and details his accomplishments before becoming licensed in California. There is no mention of contrition or rehabilitation, but his prior accomplishments are noted. At page 170 is a 2021 letter from an Ohio CPA. This letter from the Ohio CPA says that Mr. Ramanan got sabotaged and his license was, quote, revoked in vengeance, unquote. So I won't get into, that's about half of the reference letters. I won't get into the rest of them. But that concludes my summary of the case. And the petitioners have the burden of proof. And once Mr. Ramanan has testified, I will have some questions for him.
All right. Thank you, Mr. Durkar. Ms. Yamini, does your client wish to testify?
Yes, Your Honor. May I guide him through some questioning? Thank you so much.
I'll allow you to question. Mr. Ramanan, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you. Ms. Yamini.
Thank you. Good morning, Mr. Ramanan. Mr. Ramadan, you heard Deputy Attorney General's Dekar's summary of the documentation that you submitted, correct?
Can I turn it on?
Yes, go ahead and turn it on. Based
Yes.
on the summary that was read into the record, at the point when you submitted the documents that Mr. Dekar was referring to, at that point in time, was your mindset to litigate or revisit some of the factual findings made by the administrative law judge at that point in time?
At that point in time, I thought I could submit any evidence to reinstate my license. That was my
Mhm.
reading.
Mhm.
So I didn't consult you. I just prepared the package and I mailed it out. And then
Mhm.
subsequent to that, you and I talked, and you said the purpose of this is not to relitigate.
So you don't need to mention, Mr. Ramadan, any conversations we had.
Okay.
My question to you is, now that you're sitting before His Honor and the board, has your position changed? Okay. Do you dispute at this point in time any of the factual findings made by the administrative law judge? Do you believe at this point in time that you were wrongfully treated by the administrative law judge?
Well, I think I don't litigating so sure that this is reinstated.
Mr. Ramadan, could you please turn your microphone on when you're speaking?
It's turning back off.
Just,
Just don't touch it once it's
yeah,
on.
yeah,
Hello?
perfect.
Okay.
Okay, so at this point in time, do you take full responsibility for all the factual findings made by the administrative law judge?
Yes, because I was the owner of the firm, and even though my employees may have messed it up, it's the final responsibility is on me. So I
Okay.
take full responsibility.
All right, so just so I don't talk over you, if I raise my hand like this, I need you to pause so that I can ask the next question, okay? All right, so let's start with this. What mistakes do you think you committed that led to disciplinary action by the board against your license?
So I have described this in my personal statement in detail. How it happened was I purchased a CPA practice known as Allen R. David Accountancy Corporation, and there was Allen R. David Accountancy Corporation. So it was, as I mentioned, I was with a big four firm, mainly Ernst & Young, Coopers & Lybrand, and KPMG, mainly overseas. And then I was with Grant Thornton in San Francisco. So these are all big firms, and I never had any exposure to acquiring a small practice. So, but when I acquired this practice, there were numerous issues that I had to go through. Am I clear? I don't know if you can.
There's no echo. Go on.
Yeah. So I was really overwhelmed during that period of time, mainly because I didn't manage my employees properly, and 2002 and 2003, I had a young family to support, and I was transitioning a disorganized practice into my own accounting practice, and I was loaded with large loans basically. So, and then I had to, and also my seller was competing with me, as it was found in an arbitration that he had been competing by taking clients to his house and working with them. So it was all different factors, and I was really, really overwhelmed. I may have overlooked, particularly focusing on this employee, what kind of role he was playing. So talking about this employee, Nalin Ramalingam, he was, in fact, he was a highly competent accountant, and he was, in fact, the finance director in Sri Lanka for a company. And then he moved to Botswana, and then he moved to Canada. So in Canada, he didn't find any job. But I have known this person from my home country, because he was in and out of our house, and he's known to my parents. He's known to my brother's friend, And so we were very close. So I didn't expect him. So when I brought him in here, I just didn't monitor him properly. And I basically assigned him 3 clients to handle. So one of them was Systat. So Systat software, SYSTAT. Let me get some water. So, so to tell, I mean, this person, I've known him for several years back in Sri Lanka. And in fact, you know, for my wedding, he was the one who was driving my chauffeur with my wife and I in a car. So we were very close, and it's like a family. So I never expected him to walk into my office one day and say, I filed a case against you. So I said, what's going on? What is it? And he said, I filed a case that you had to pay me overtime. So at that point in time, I was shocked and I was disappointed. So I said, okay, now I had to defend my firm. You know, I didn't hire you. You were hired on an H-1B visa, which is only given to professionals. You are not a low-end person. So you don't qualify for overtime. So that case, I had to defend it. So in that case, there were a number of, you know, it went on for a while. And at the same time, Mr. David was acting contrary to my firm's interest. He was promoting the employees to file overtime cases against me. So practically 3 or 4 employees started filing overtime cases. So in defending this case, finally, the case went through Superior Court, Court of Appeals, and then Nalin Ramalingam was asked to pay my attorney fees by the Court of Appeals. So he decided to go to Canada. So anyway, and then from Canada, he wrote a complaint to the board. And first the board disregarded the complaint. And then he got hold of another employee who again, disgruntled employee who was working with Alan David to rewrite the complaint and on which the board contacted me. And the initial contact was about independence issue.
So I'm going to raise my hand now.
Sure.
So you gave us some background information as to your relationship with, is it Nalin? Is that how you pronounce his name? Nalin?
Nalin.
Okay. I think for our interest, I'd like the focus to be on the findings made by the administrative law judge, mainly the first finding, which was that the company, meaning your accounting company, failed to maintain independence with respect to Sistat. Do you agree with that finding?
Yes, yes.
So what does it mean to you? What is independent? Why is it important for an accounting firm to preserve and maintain its independence when it comes to auditing or servicing a client?
Well, independence of financial audit has been there for several years. So it's not something new for me because I worked with Ernst & Young, Coopers & Lybrand, and KPMG in audit division. So we know that independence is a core matter in any financial audit because the independent accountant has to maintain independence in appearance and also in fact. So
But why is that important?
Because it's a public, I'm sorry.
No problem. I don't mean to talk over you. What purpose does that serve with respect to public safety?
It's protection of the public interest.
How so?
Because the public has to rely on the financial statements where the auditor has expressed an opinion and issued an audit report. So that audit report is something valuable to the public, and they rely on it to rely on the numbers.
So do you agree with the finding that Nalin was actually serving as a chief financial officer for Sistat while your accounting firm was or was performing an audit for Sistat? Do you agree with that finding?
It's a subjective question because the AICPA rules and especially the ethics committee has specified how an independence should be evaluated for a member. There are certain threats to independence. There are 5 or 6 different categories under which independence should be evaluated. So for me, again, to restate my previous statement where I brought him in and I didn't manage him properly. And I just said, go and learn the work. You are new in the country, go and learn the work at Sistad and two other companies. And the other two companies, he didn't go there, but Sistad, he used to go. But what happened was that initially when somebody walks in, even though he was a finance director in Sri Lanka, I'm sorry, okay, all right. So even though he was a finance director in Sri Lanka, and when you come into a country like USA, where as a new immigrant, you have no knowledge about the local system. You don't know what IRS is, you don't know where franchise tax board is, you don't know what board of equalization. So all of that he has to learn. So I told him, hey, take it as your chance to learn the system here. So I let him be on his own maybe because of my family connection. And I didn't supervise because I was overwhelmed with the other things that are going on in my firm, which is relating to the acquisition of Alan R. David Accountancy Corporation. So I had a huge debt to pay off. And I had to really be focused on saving the clients, at the same time transitioning the business, understanding Alan's business, improving the processes there. He never had any time entry system. So I had to go through all that and understand every client's issues and to know about and to transition the business properly. So I was really overwhelmed. So I didn't check on this guy, what he was doing there at Sistad, but sorry.
No problem. Can you explain to members of the board and his honor how Nalin was introduced to Sistat to begin with? Did you specifically assign him to that particular client?
Yes, yes.
Okay. Did you at any point become aware that he was serving a role as a chief financial officer at Sistat?
No, not as a chief financial officer, but eventually after 2 years, he gained knowledge and experience in US. And then he was more of a consultant advising. He will come and talk to me about various issues with the client. And I will tell him that, I will explain to him, I'll teach him, and he will go back. And he kind of got to a point where he became more of a consultant to the client. So I'm sorry.
What was your understanding of the role that this gentleman was playing at Sistat?
Mainly he goes there twice a week, or at times 3 times a week, 3 days a week. And he will do some help them with invoicing. And then he would advise the general manager, his name is Tanvir Kada, that AR is growing, AR is building up. Okay, so you have to start collecting money, because you will need these cash flow issues coming up next month. So he will kind of promptly give that advice. So providing advice in terms of rules that were prevalent in that year was perfectly fine. It doesn't impair independence. You can sit in a meeting with the staff, with the client, and you can act in the capacity of a consultant advising the client, but you don't step into the shoes of the client. You don't make decisions for the client.
That was your understanding at the time of
Yes,
the role
yes.
that he played? Okay.
Absolutely, yes.
Is it now possible, after what you learned in the administrative law hearing and after reviewing the administrative law judge's decision, is it now possible that Mr. Nalin actually played a more active role than you thought at the time in Sistat, in retrospect?
Well, I think the accusation and the ALJ hearing specifically says he made management decisions. I don't see any management decision was cited to me that he made. He may have sat in a meeting, he may have provided input to the client, which always accountants do. We always provide accountants in clients' advice, tax-wise or otherwise. So I was looking for one single decision that he made, and it was never cited in any of the.
So initially, Mr. Ramanan, we started with the premise that you are not challenging or disputing any of the factual findings made by the ALJ. one of the factual findings was that your accounting firm did not maintain proper independence, that the independence was compromised with respect to Sistat. My question to you is, do you agree with that finding?
Now that we have gone through several stages of litigation, I would like, I mean, I'm not going to relitigate the issues unless anybody can ask me questions, but but I don't want to relitigate the issues, and I accept the decision of the board.
Okay, so if you accept the decision of the judge, the administrative law judge, can you explain how your accounting firm compromised its independence with respect to Sistat and what your error in that regard was?
Well, I think the decision says that he acted in a management capacity. So obviously, in that case, I mean, I really didn't know about it. I didn't even know what he was doing. So it was my fault that I didn't monitor him properly. We had meetings. He will come back and tell me what's going on. But he became too friendly with the client. So over 2 years. So initially he didn't know anything. He just, he basically has started very fresh. But maybe towards the end of second year, he became too friendly. And also, if you read my case earlier on, he even Sistad hired him after terminating services with us. So he was hired through another firm, his brother's firm. And he also got a business card from Sistad. So this all happened behind my back. And maybe he was 2 steps ahead of me. I was sorry. Okay.
That's okay. What could you have done differently with respect to your management and supervision of this gentleman who's working for your accounting firm to prevent this type of inappropriate relationship between him and a client that the accounting firm was auditing?
So we don't have anyone going to clients' offices in nowadays. We don't have anybody, and we did not have after this incident. We completely stopped anyone going and sitting in a client's office and doing work. So they can go there for meetings. That's it, and they don't. And then that's pretty much it. So basically, maybe I probably should have gone out with him. I did go out there a few times, but I didn't probably go out with him more often and manage his time.
So was this a failure to properly supervise and apprise yourself of what your employees were doing issue? Was it a lack of supervision issue?
Yes, we had a team of audit team. I had an audit manager. His name is Alan Razaya, CPA. And under him, there are 4 people doing the audit. So I didn't think it was necessary for me to inject myself too much into walking into the client office when I had all these professionals working in the firm.
And has your attitude changed now with respect to how you should supervise employees if your license were to be reinstated? So to prevent the compromising of independence.
Yes, absolutely. We have we have implemented new procedures, and we have adopted AICPA's training manuals, and we have implemented employee manuals. We trained them, and we have absolutely explained to them about the independence issues. And we also, but right now we don't do any audits because my license got revoked in 2019. So until that, we were also I went through the peer review twice. And both peer reviews, our firm passed with no deficiencies at all, just straight pass, 2 years. So we have implemented systems because, as I told you, I walked into a practice that did not have any proper procedures, and I had to rebuild everything from scratch. So yes, it was overwhelming. It was stressful. It was very bad timing for me. Because I had, as I told you, I had a young family to support, and then I had to, I was having too many issues with Alan David. So Now, to answer your question, yes, we have implemented procedures. We have now, how all our, so, we are using Microsoft Azure for to keep all our documents, and everything is backed up with 90 days backup. And it's a cloud service. So we use the, nobody can log into the system. They have to only do it with dual authentication. They have to accept the invitation through the cell phone. So all kinds of systems have been now put in place, which never existed in Alan's practice. So it was my hard work to build up the practice in that direction.
Now that we talked about the independence issue, the second set of findings by the administrative law judge regarded the actual auditing itself, and the ALJ found that there was gross negligence in the manner in which the auditing for Sistat was performed. Do you dispute that finding?
Well, now that the case is done, I'm not disputing that. I'm not disputing the decision.
So what do you think your mistake was in the manner in which the auditing for Sistat was done at your accounting firm?
So as I told you, I had another CPA as the audit manager. His name is Anton Razaya, CPA. And then we had Anton, Anton. Last name is Razaya, Rasiah. Rasiah. So he moved to Ohio. So I'm sorry, I missed your question.
The question was, can you articulate what your mistake was or what errors you committed that resulted in the audit for Sistat being performed in the manner that it was?
Yeah, so as I said, lack of supervision, maybe because I had a CPA who is a experienced CPA in audits, and I had to trust him, and maybe I could have had a little bit more insight into how the audit was performed. But I think I had a good idea, global idea, but then I had to rely on my subordinates also to get the work done, because obviously in a big firm like Cooper's or Price Waterhouse, the partner is not going to go to the field work and do the field work. So partner has to rely on the team and the audit manager, supervisor, and the seniors and juniors. So I relied on the audit work papers prepared by him. So did I answer you?
What mechanisms would you implement if your license were to be reinstated? Would you implement in order to prevent the mistakes that were made here in terms of the Sistat auditing?
Okay, so we don't do any audits now because we don't have the license to audit. So
if your license were to be reinstated?
Yeah, so in terms of independence, we have better training, and everybody takes training materials. We have we have implemented new procedures, and then we also subscribe to a lot of professional subscriptions to professional libraries, CCH and Thomson Reuters. CCH is from Walters Kluwer. So we follow their accepted practices, and then we follow through every step of the way. And all the work papers are signed off by the preparer, signed off by the reviewer, and signed off by the partner. And that practice is being now followed for my tax work. Even my tax work is pretty much the preparer signs off, and we have a first level review and a second level review. And I'm sorry. All right. Where did I stop? Yeah, so we have different levels of sign off on a work paper. That's required for an audit, but for a non-attest function or service, we have still included that. We still do that for even tax preparation. We just make sure that tax preparation, typically we are moving towards a paperless environment back in 2002 and 2003. So we were using the PPCs, audit procedures and checkpoints and all that. So now even right now we are using PPC's work paper CS. PPC, that's a company, it's from Thomson Reuters. So we have even the tax work papers are signed off by the preparer and a reviewer, and then the partner, a final sign off. So
So we have done a lot of improvements, a lot of implementation, and this was the issues that we are talking about happened in 2002 and 2003, where the standards were evolving after the Enron case, and standards were evolving more and more. And especially, I've included that in my personal statement that we had a Statement of Accounting Standards 41 and 96 were applicable to the audits. But a lot of the report release date or independent reviewer standard was introduced all in 2016. I'm sorry, 2006. So for the audits that we are considering here, which happened in 2002, 3, 2000, March 31st, 2003 and March 31st, 2004, these standards didn't even exist. That an independent AICPA standard, maybe it appeared under the Business and Professions Code sections. I'm not too sure because I was trained to work as a CPA and not as an attorney. So that's what I mean. That's why I looked at the ICPA standards. It was not applicable for those audits. Yes.
You had mentioned in your petition to the board previously, and Mr. Dakar had read it into the record, the statement that you don't believe that the public was harmed or the public was not harmed. Is that your attitude today?
Public was not harmed as a result of.
Yes. Do you believe that the mistakes that you made, particularly the lack of supervision with respect to your employees and what was going on under your nose in your accounting firm, do you believe that could have potentially harmed the public?
It could potentially harm if something went wrong.
Okay.
But there's nothing went wrong in the audit. So because the audit financial statements were never restated, it was right through it. If there was a problem with the audit, because as I told you earlier, I was trained as a CPA, as an auditor. I was not trained as an attorney. So my focus in these charges were how do I defend my audit opinion? So, but I didn't realize that the attorney who was prosecuting me was taking a different angle, which I never even thought was going to happen. So I was focused on audit opinion, audit report. Did anything go wrong with the audit? So I thought the ultimate test for this would be the numbers are wrong or the financial statements are wrong. Financial statements are misleading. But that didn't happen. But I think my attorney also didn't advise me that there could be a potential dishonesty charge, which I never even thought that was going to be an issue.
Mr. Ramadan, what sort of continuing education classes or courses have you completed in order to address some of the mistakes made here by your firm and by you personally?
Well, I have taken continuing education courses right throughout up until, even up until this year. So I think some of them have been already included in the package here. And as I told you again, we had a peer review where we passed the firm systems peer review, which is basically for anybody who is doing a test work. So we passed system peer review with no deficiencies. And we also had a monitor. We had a supervisor. Our practice was supervised until it was revoked in November 2019. So my supervisor didn't have any issues with the work that we were doing. And he signed off on it. So I have taken enough CPE courses to satisfy the board's requirement up until the time that I was revoked. Now, when this happened, so I went ahead and got myself registered as a tax preparer. Okay, well, after the board revoked my certificate, I went ahead and it was a terrible time for me. I couldn't believe, because this is the only profession I know. I have been an accountant since the age of 22, 23. I never worked anywhere else. I always have been an accountant. So I thought, what am I going to do? So for about 6 months, and it was COVID, and then I went ahead and registered myself. I had to continue to support my family. So I got myself registered as a certified tax preparer in California. So I continue to work as a tax preparer.
Why should the board reinstate your license as an accountant?
I believe the reason is that, again, as I told you, this is the only profession I know. And I have been an accountant from Sri Lanka from the age of 22, 23. And now I'm going to be turning 65 in October. So I don't want to leave a black mark on my career. So I think it hurts a lot when somebody comes and tells me your license is revoked and we see that on the web. So it is a painful feeling when I hear that. So nobody knows or reads in too much into it, but they know that, oh, okay, your license has been revoked, board has revoked it, and here are the reasons. Nobody understands the reality of it. They don't understand what happened. They don't ask me what happened. So it's very hurtful feeling for me to listen to people telling me that. So I thought I need to have that cleared up in my record. As I told you, I'm 65. I may probably live for another 10 years. I don't know. And before I want to make sure that my record is clear.
Thank you, Mr. Ramanan. I don't have anything further.
Mr. Durkar, Cross?
Yes. Mr. Ramanan, you described briefly your practice since your license was revoked. You said you do tax work. Would your practice change at all if you and your corporation were reinstated?
Will that change? Yes, obviously yes.
So,
it was, change in the sense we are not doing any test work and we are doing tax work. So, but we have implemented vigorously quality control standards, even on tax matters. So if I'm reinstated, the process will continue. It's a continuous improvement, yes.
In your own words, what misconduct did you commit that resulted in the revocation of your license?
Again, as I told you, most of the issues happened behind my back. I didn't know anything until, as I told you again, they were always 2 steps ahead of me and I was catching up on them. And so in terms of people I bought this practice from Mr. David, and Mr. David had been causing a lot of issues. And then just imagine, how would a CPA go and remove my board, sign board from my building? That's not even, he did that overnight. So I was under a lot of tremendous pressure, Mr. Alan David one night removed the signboard from my building. And he was competing with my clients, taking over my clients, taking them to the office, his house, doing the work. And one day I got a call from Intuit. And they said, you haven't paid your bill. I said, no, we pay our bills regularly. So I said, can you send me the copy of the bill that you said we haven't paid? So they faxed me the copy of the invoice. And that invoice had the address of Alan David's home address. So, and the list of clients were there. So all of these issues really, and then the purchase contract had a 1.2 million penalty if I terminated this guy within 3 years. So the lesson I learned is, I'm sorry, Alan David, within 3 years. Within 3 years, if I terminated him, I had to pay him $1.2 million. That was a clause in the contract. So I was helpless. I was wondering, what am I going to do? He's competing, he's stealing things, clients. If I let him go, then I had to pay 1.2 million. So I was trapped basically. So finally, I had to decide at one day when he removed the signboard and all that. And then I saw those documents on his desk that he was asking the clients to come and see him at his house. Then I decided to tell him that, I changed the locks to the door, and he was upset and he went ahead and, did all kinds of damage. So anyway, just to give you an example of what happened in my firm. So it took a while for me to take control and put everything back in place. So I'm sorry, I missed your question. Did I
My question was, in your own words, what misconduct did you commit that resulted in the revocation of your license?
Lack of supervision, maybe lack of supervision of the staff. And the reason is obviously, too much was going on. And so that's basically my issue was.
The board also reached a number of findings of dishonesty, both during the investigation in 2008, and then documents that you subsequently produced that were found not to be the actual audit papers, and then dishonest testimony and responses that you gave during an investigative hearing and at the hearing on the accusation. Do you admit to any of the findings of dishonesty that were reached against you?
Well, I mean, it's too late for me to challenge them, but I can explain to you. In some cases, there was some wrong interpretation. For example, I was with the administrative hearing. They asked me about internal control documentation to test the internal controls. So I was telling them that those are the documents my assembly workers sent to the board because we were only dealing with independence issue. When I realized that our board is now after audit deficiencies, I said that everything was electronically done and the internal control questionnaire and the answers would be there. That's what I said, would be there. But when I read the brief from the Deputy Attorney General, he said, Mr. Ramanan said he left the internal control questionnaire at the client site. So things like that, there were a lot of discrepancies in when a court reporter took the notes and how it was interpreted. So, so again, as I told you, I'm not going to relitigate that. I don't want to go through that because it's really a painful part of my life.
Do you believe that bad audits which violate professional standards are harmful to the accounting profession?
Violation of professional standards, yeah, obviously.
How so?
Violation of professional standards will violate the public interest. Is that your question?
Well, I'm asking you to explain why you believe that violation of professional standards is harmful to the profession.
Obviously, because as I told you earlier, the financial, the public rely on the financial statements, which have been audited by an independent CPA. So when they rely on the financial statements, it adds value to the, when they rely on the auditor's report, it adds value to the financial statements. So that's the main reason that the professional standards and board rules and business and professions code sections are definitely to protect the public. That's the reason why it is important. Yeah.
Your Honor, those are all the questions I have.
All right, thank you. Turn it over to the board. Ms. Salazar.
Thank you for your testimony. In your packet, I see that you included two letters of recommendation from long-standing clients. So those are at page 163 and 166. Those are a few years old. Can you speak about your current relationship with those individuals?
Sorry, which one are you talking about?
Your letters of recommendation at 163.
Yes.
And so my question is, are you still connected with those longstanding clients? And did
Yes,
you
yes.
consider getting an updated letter to include with your packet?
Yeah, I could. When I read the board's decision, it said that I can apply for reinstatement after 1 year. So I started on working on that process after 1 year. So that's the reason I started collecting all these letters of recommendation. So he's still a client of mine, so if he can always write another letter. But so then I was told that 1 year is too soon to ask for reinstatement because it hasn't given enough length of time for rehabilitation. So then I was advised that I should wait for 3 or 4 years. I mean, I would have preferred to do it in 1 year, but
Thank you.
Thank you again for your testimony. Part of the order that was submitted included reimbursing the CBA for reasonable costs of over 100,000. Have you made that payment? And if you haven't, why not?
well, the decision says that the board can ask for reimbursement when I submit for petition for reinstatement. Okay, when the reinstatement happens. So that's what the decision says. I don't have to pay. I didn't have to pay that at that time, only when I submit the petition. So, and also my understanding was that the board can recover cost up until the time when the hearing started. So the board and the $141,000 includes cost of the attorneys during ALJ hearing. But I think I researched that. I noted it down in one of the Business and Professions Code section. It says that any cost after the hearing started cannot be recovered. So that's another matter that I would like you to consider, please.
I would object that the costs were disputed and litigated, and the board previously decided what they were.
Yeah, I would note for the record that they were deemed reasonable in the decision, so.
No other questions.
Mr. Rosenbaum?
Yes, I guess I just want to go back to one or two things. When Nayland, is that?
Nalin, yes.
When he was assigned to Sistat, what were the terms of the billing arrangement between your firm and the client?
The billing arrangement is based on, his number of hours. And we had a fixed fee for online support. And it was probably something like 2,000 a month or 3,000 a month for somebody to support. So, and then we had a billing arrangement where we would charge them separate for tax work. And so that's pretty much the arrangement
Was in the arrangement letter, did it delineate what tasks Nayland was going to perform?
Mainly, I mean, nothing so specific, but he was supposed to be helping the client with their compliance matters. And obviously, he didn't have that knowledge in the first year. So they wanted somebody to come.
Correct. But when you say compliance, are you talking tax compliance?
Tax compliance, yes. Filing the sales tax returns and income tax returns, and helping them with his bookkeeping entries and stuff like that. Yeah.
I'm not familiar with that company, but he was spending 2 to 3 days a week for 2 years.
Pretty much, yeah. Yes, because what happened was that this parent company is based out in Bangalore, India. So they bought out a product line in the US called Sistat, which is a statistical analytical program. So they formed this company to take over that product line, and they were in early stages of moving into the US. So they formed a company in Delaware, and they wanted someone locally here to be able to help them with the initial, what do we do here? What do we do with in terms of filing tax returns and sales tax returns? Because they took over the product lines from another company. So it was a very small company. I think the maximum they had was later towards the second year, 10 employees. That's the maximum. So it's not the company that we are talking in terms of size. It's not like, IBM or Cisco or anything like that. It's 10 people company. And they had a general manager. And so that, and fully controlled. And also our audit report were restricted use. It's a restricted use audit report, basically saying nobody else can rely on this statement, on this report. Only the parent company can rely. Because they are the ones who said we want an audit done. So we issued a restricted use audit report.
Okay,
So
thank,
in every aspect of it, we were very clear that the public interest is protected.
I see. So one of the things at the outset, you and your attorney wanted to make clear that this was more about rehabilitation and not about relitigation.
Sure.
But it does seem that in your submission, it is about relitigation. The letters, as Mr. Durkar pointed out, really all allude to the fact that it was not your fault. Whereas the decisions that have been made do indicate some very severe culpability on your part. In fact, even when your attorney asked, do you take responsibility and do you basically accede to the ALJ, and you said, well, maybe not in my personal opinion, but that's really what we're here for, is
Sure.
is your personal opinion. And so even when Mr. Durkar asked you, what did you do? What was your culpability? Your responses were that issues happened behind your back, which isn't taking responsibility, or your lack of supervision. But I think there were some other things within the ALJ decision that were much more specific to your actions, not just your lack of supervision. So I'd like to ask Mr. Durkar's question to you again. What do you see as your culpability? And how have you rehabilitated yourself in the time since 2019?
Okay. Um, so the fact that we have new procedures, again, this matter goes back to 2002 and 2003 timeframe. So now we are 20 years after that incident. So in that 20-year period, a lot happened. We have implemented new procedures. I think I have clearly stated in my personal statement what the mitigating factors are. We had, again, we have much more stringent rules and regulations in terms of doing work. Right now, we don't do any audits, but in terms of even tax work, we have staff, we have regular training for the staff. We have regular training, new, and we update our training manuals. We have operating manual implemented in our system, in our company. So, and people can refer back to that. And our computer systems are all now in cloud-based systems. So nobody can steal away from this, from taking manual work papers. And we have clock in, clock out system now. People will have to come in and clock into the office and clock out. So I think I would like to specifically address, if you can point me to something that in the ALJ's decision, I can tell you how I have rehabilitated myself. Okay, so I think when you go through this, example, the ALJ's decision says respondents failed to receive legal representation letters. They didn't have any attorneys. It's a small company, so that's one aspect. He said that we failed. So he said we didn't consider the audit risk at the individual account balances or class transactions level for 23 and 24. So including inquiring into the professional reputation of the auditor, that ALJ said that he didn't agree with that. So let me go back to any of the other pages here. So on one of the pages, ALJ saying, initially, it's not that Ramanan's testimony in many of these matters was incomplete, evasive, or so he said it's not. So the other issue was that I couldn't bring anybody. So Anton Razaya moved to Ohio. I called him and asked him to testify, and nobody people are hesitant to testify, especially with, in front of the board, right? So, and then my attorney said, he lives in Ohio, you can't bring him here, and you have to do some special arrangement. So, again, going back to this, the other one here, it says, complainant did not establish respond. Okay, so that's in our favor. There was one typographic error, which I said typographic error because they moved the same in the auditor's report. And a lot of these, when I go through this, so the independence about the.
Excuse me, what pages, what
I think
pages?
mine got chopped off at the bottom. I got the email and download. I know what page it is.
Referring to your personal statement?
No, I'm referring to the ALJ's decision.
The ALJ's decision. Okay, let me see.
We have a
what
copy
page.
there.
Begins on page 116, I believe.
Thank you. Thank you, Your Honor.
So ALJ, I don't have the page number here. So it says,
I can give my electronic version to you.
Nalin Ramalingam had extensive participation in important management decisions at Sistas. So, yeah, sure.
We have
I'm
the
sorry.
page numbers here.
You have the page numbers here.
And we have the electronic version too.
120. It's page 125.
125.
State the paragraph number as well.
Thank you so much.
So on second paragraph. Okay, so I think the first paragraph, ALJ is saying respondent Ramanan's testimony in Nalin versus Nika, where it served his interest to emphasize Nalin Ramalingam's high-level management role at Sistad was fundamentally at odds with his testimony in this matter. So there are two different cases. So there we were dealing with a wage and hour case. And it's clearly stated in my personal statement. So, and also most of the statements were made by my attorney. And obviously I understand if the attorney says something on my behalf, it's presumed to be my statements, right? So that's how it is being referred here. My attorney is the one who said use certain words. Extensive participation in management decision. Participation under the rules in 2002 and 2003 does not impair independence. He can participate, but he doesn't step into the shoes of the company, the auditee. So then we talk about gross negligence. So on the next page, I'm a bit confused about this. It says it's not the Ramanan's testimony on many of these matters was incomplete, evasive, and unpersuasive. So if his testimony, he says is not. So then he goes on to say, respondent's second submission was not shown to be the actual work papers for the 2003-2004 reports. So I'm confused at that level whether is it my burden to say prove or is it, I don't know.
Mr. Rahman, I'm sorry to interrupt. I have read that.
Sure.
So I know what it said.
Okay.
I don't know if you have anything further to add, but otherwise I have no further questions, Your Honor.
Oh, did I answer your question properly or no? Did I answer?
No.
Okay, so please restate the question to me then.
Well, I think you answered part of it, Mr. Ramanan, in terms of what steps you've taken to prevent similar issues in the future.
Yeah, I think I have testified that earlier that we don't have anybody going out to the client site anymore and doing work from there.
I understand, but
yeah.
Mr. Rosenbaum's initial question was, what culpability do you accept in this matter? And I'm not sure I've heard you testify on that.
Okay. When the inquiry was about independence and then it expanded into audit deficiencies, I had to defend the audit opinion. So I had to go through my, um, you know, old computer drives and then reassemble the work papers. And that is under the previous rule. It was perfectly fine because there was no audit report completion date and there's no release date, report release date, because again, that's in my write up here. So the auditor can substantiate his audit report by other means. That's how the standards refer to that during that period. The auditor is not precluded from supporting his audit report through other means. So other means was any other documents that that I could find that would substantiate the audit work.
Your Honor, I apologize for interrupting. Is it okay respectfully if I rephrase the question? I'm just wondering if Mr. Ramanan understood the question or not. Would that be okay?
That would be fine.
Mr. Ramanan, His Honor is asking, when he is asking, what was your culpability in this matter? The question is, what did you do wrong? That's the question. You're answering it in terms of, you know, events that happened, but the question is, what did you do wrong? What was your responsibility in the outcome of this audit? What did you do wrong? That's the question that's being asked. Do you understand the question?
Okay. Yeah, I think I testified to that because I was overwhelmed with my work and I relied on, because of Nalin Ramalingam was part of the family, so I didn't supervise him properly. So those are my issues. I mean, I accept responsibility for that because I should have been more active, more careful with the audit work. So I accept responsibility for that. And that's what I'm saying, that we have made a lot of improvements after this incident. And we won't have any other mistakes like that because currently my kids are, at that time my kids were very young and now they have grown. So I don't think I'm going to have any, the anxiety that I had at that time. So that's a big relief for me because at that time, it's caused a lot of stress, even in the family, that we are young kids, we have to put them through education, university and all that. So now all those burden is now no longer there. So I have kind of gone through that stage and I think I managed to come out of it. And we have done a lot of improvements to our, specifically if you say, we subscribe to CCH, for example, okay, and there is advanced flow, which is Thomson Reuters product. So everything is, we are staying current, up to date on every standard, everything, every professional standard, and also we are pretty much, we subscribe to various agencies like, National Association of Tax Preparers and, so we are continuously staying on top of all the regulations to make sure that we don't miss any of those. So that's all I can say.
Thank you.
This too.
My question has been answered. Asked. Thank you.
Ms. Lada?
Thank you, Your Honor. Thank you for appearing today, Mr. Ramanan. In the factual findings related to dishonesty, in your own words, how were you dishonest?
Now, again, I think the focus here is not to relitigate. So I think there are a number of how I was dishonest. Maybe the fact that I had to defend the audit opinion without realizing the emphasis on the dishonesty charge. I had to assemble the work papers from various drives and in the process of defending the audit opinion, which I thought was okay because the auditors could support their audit opinion with other means. We didn't create any new work papers because Systat was no longer a client of ours. So Systat is no longer a client of ours. So all what I was able to compile was all through our internal records. And I had maybe my judgment was wrong there. So I thought it was the auditing standards said that auditor is not prevented from supporting the audit opinion through other means. And so maybe my understanding was wrong. So
Thank you. No further questions.
Mr. Jacobson,
I had no questions, Your Honor.
Ms. Batchelor,
Questions?
Mr. Aguilar.
Thank you for being here today. I'm going to try to ask a couple of questions. So one of the benefits of this setting here is you have a chance to answer in narrative form, which is really, really important because we want to know all the facts and circumstances, because something at first blush might look different if you knew all the facts behind it. So with that in mind, I'm still going to try to ask you a couple of questions where it's just yes or no, or maybe a few words, just to try to be as direct as possible. So the submission was, as I understand it, was sent in February, and it really does read like a relitigation. And at my first blush, I thought, well, it looks like this is boiled down to just two problems, but looks like there's more than just two problems. But as I understand it, you've had a change of heart, and now you're no longer want to relitigate or argue the past. When did you have that change of heart?
recently, after talking to my attorney, and after going through 3 years, I was kind of thinking to myself, and I was told that this is not the platform to relitigate.
Why haven't you made any attempts to make payment?
The decision itself says that it's, I think on one of these pages here, it says it's breaking down the outside consultants, and one is this is too much. I mean, I can't afford to pay $141,000.
Right. Could you have paid like $20 a month or $100 a month? Or...
Definitely, yeah. I mean, I can do that, but then on the final page, it says, upon petition for reinstatement of their licenses, it says, respondents will be responsible for paying those costs upon any petition for reinstatement of their licenses. So I read that and I understood that until I go for the petition for reinstatement, there's no payment required.
Yeah. Okay. Thank you. And then, were you dishonest during the prior proceedings?
Whether I was dishonest?
Yeah.
In terms of the subject matter, I testified, and it may, I can't think of any specific instance, but then definitely the facts as the ALJ found, I'm not going to dispute that.
Okay.
So
thank you.
Ms. Thompson,
I have no additional questions.
Ms. Hines.
Thank you for coming today. You mentioned that for your letters of recommendation, because they are a couple of years old, you could go, those are still your clients, you could go back and you could get new letters of recommendation from them. Do you understand what those letters need to say? What kind of information needs to be in those letters if you were to go back and ask those clients to provide additional letters of recommendation?
no, I don't understand that. I think what you're saying to not talk about the case, is that how it should be? I don't know. I don't know what it should say.
Well, I mean, I'm not going to counsel you on it, but I'm trying to get an idea of whether or not you understand what we need to hear in order to be able to make a decision about whether or not to grant your request, and what the information that you're providing needs to say, and what kinds of information we need to be able to make a good decision. So,
Yeah, but I didn't, I mean, basically these letters of recommendation, I just told them in what context I wanted the letter of recommendation, and they wrote it themselves. So I told them, this is my feeling, this is what it happened. And maybe they would have reflected my feeling. And then ultimately in the letter, they would have said, you know, because I think basically what they were trying to do is that they wanted to express that they know the case, you know, instead of saying, oh, I simply recommend Subramanian Ramanan for reinstatement. They want to, knowing all these facts, and we are recommending. Probably that's the reason they wrote, because I didn't write these letters for them. They wrote it themselves.
okay, so let me ask a little follow-up then. They're a few years old. You've testified that you've had a change of heart. If you were to go back to these clients, could they talk about, you know, the difference in you as a professional today versus when they wrote the letters before? Could they talk about the quality of your work? Could they talk about your reputation, your credibility? Could they provide that kind of information if you were to go back to them? And
They would. I mean, if I asked them to, but some of them are, I think one of them is, he was the chair of KPMG for countries in Asian countries. So, you know, he lives abroad. So depending on the availability, yes, definitely.
all right, thank you. That's all.
Mr. Durkar?
Have any further questions, but I do have some closing remarks I'd like to offer.
Ms. Yamini, any further questions for your client?
Nothing further, Your Honor. Thank you.
Mr. Rahman, I'm going to ask you a question, just kind of building off the question that Mr. Durkar asked you. And I understand your position that you don't want to relitigate anything in the prior case. But acknowledging wrongdoing is one of the essential steps in rehabilitation. And Mr. Durkar asked you, were you dishonest? And it's been asked several different times, but can you, in your own words, say how you were dishonest? If you actually accept the findings of the ALJ. If you don't, feel free to say that, but if you accept them, how were you dishonest?
Okay. In terms of dishonesty, again, I think I don't see anything major but if I want to think about something,
Let me ask you this. Do you believe that you were dishonest?
honestly, I don't. So,
okay, thank you. Any further questions from the board? All right. All right, well, thank you for your testimony, sir.
Thank you very much. Yeah.
Mr. Durkar, I will turn to you first for closing remarks.
Thank you, Your Honor. There are considerable public safety concerns here as it relates to rehabilitation. The process of rehabilitation really cannot begin while someone denies wrongdoing. And, you know, for many years here, Mr. Ramanan waged a legal battle to avoid responsibility. And he's no longer technically fighting the board's order and decision, but he hasn't acknowledged his role in the wrongdoing. He blames employees and he minimizes his own misconduct. The process of rehabilitation really has to start with acknowledging the wrongfulness of one's own actions. This California Supreme Court said so about another petitioner, saying, and I quote, fully acknowledging the wrongfulness of his actions is an essential step towards rehabilitation, unquote. That's SEIDE, SEIDE versus Commission of Bar Examiners, a 1989 case, 49 Cal 3rd, 933 at page 940. And so has Mr. Ramanan taken that essential first step? It appears no. And has he coupled his acknowledgement of wrongdoing with a sustained exemplary conduct over an extended period of time? That second element, sustained exemplary conduct, I don't think we have much, if any, evidence of that aspect of rehabilitation, of exemplary conduct, the letters, the reference letters that he submitted, just attest to how he told his clients and colleagues that he hadn't done anything wrong, and then he got railroaded by the process. So we don't have the evidence here that could be viewed as any real rehabilitation, just rather a desire to be reinstated for the benefits that would confer on him. So with that stated, I think you have all the information you need to reach a decision in this case. Thank you, Your Honor.
Thank you, Mr. Durkar. Ms. Yamini.
Yes, Your Honor, very briefly. I guess.
Microphone.
Okay, thank you. Can you hear me better now? Thank you. I guess the issue really here is when we talk about rehabilitation, I mean, what we're really concerned about is public safety. If we were to reinstate Mr. Ramanan's license and if he were to resume practicing as an accountant, would the public really be harmed by his practice or his practicing as an accountant? And of course, rehabilitation is really the key determination to that analysis. But a showing of rehabilitation is never perfect. A showing of remorse is never perfect. I don't know if any petitioners have ever 100% expressed remorse in these proceedings. Maybe I'm wrong, but in my line of work, it's never at 100%. I think that the analysis respectfully should be the totality of the testimony and the totality of what was presented by Mr. Ramanan. And while I agree, there were certain things that he could not agree with, such as the perception or the analysis of whether he was dishonest or not. Fundamentally, I would respectfully argue there was an expression of sufficient accountability in the sense that he did testify repeatedly that these problems arose and disciplinary action was engendered primarily because he negligently supervised his staff. And at the end of the day, whether he says to you, this is all my fault, I did A, B, and C, or I didn't properly supervise my staff, things were going on under my nose or behind my back that I wasn't aware of, the fact remains that the buck stops with him. Whether he was consciously aware of what, for instance, Nalene was doing at Sistat, or he turned a blind eye, or he was willfully ignorant, or he negligently supervised him, the result was the same. The result was he failed to properly manage his accounting firm. And that's the fundamental culpability here that he articulated. Was it perfect? No. Was he struggling? Absolutely. But like I stated earlier, I'm not sure how perfect an expression of remorse can be in these proceedings. The question then is, do we have rehabilitation? We do know that Mr. Ramanan has undertaken measures in order to address the mistakes that were made that led to disciplinary conduct, and those measures are concrete. We also know that he understands the destructive outcome of properly supervising or managing your staff or turning a blind eye to what they're doing, which is what he did. And he explained it in terms of the stress he was under. It's very difficult for any of us, and including the administrative law judge, with all due respect to him, to get into the mindset of the actors here. I think we can all surmise to some extent what actually those mindsets were, what people subjectively knew or were aware of. But at the end of the day, as I stated earlier, the buck stops with him, and he's responsible for whatever mistakes his accounting firm made. And he made that very clear. I think that with respect to the question of public safety, we do know that Mr. Ramanan has undertaken measures that are concrete, very concrete in nature to address these mistakes. I think if the board were to reinstate his license, I don't think those mistakes would repeat themselves, his flawed expression of accountability notwithstanding. I think he is fundamentally aware and sufficiently aware of what he needs to do to prevent negligent auditing from happening. I think he's fundamentally aware of what he needs to do to prevent the company's independence being compromised when it comes to auditing a certain client. And I think if the board's concern is, I would respectfully argue, strike that please, that the goal here should be to devise an outcome that's not punitive. We're not here to punish him. We're here to come up with an outcome that sufficiently addresses public safety. And that outcome may very well be a probationary license where he's required to resume taking certain educational courses, where perhaps some level of supervision needs to be provided during his first year or second year of working as an accountant. If a restricted or probationary license is sufficient to address public safety, then I would respectfully argue or submit to you that that would be the appropriate outcome. But denying him licensure based on flawed expressions of accountability, I would respectfully argue may not be the proper analysis here. Thank you so much.
Thank you, Ms. Yamini. Mr. Ramanan, you've heard me say this, I think, a couple times now, but the board will go into closed session to deliberate on your petition, and you'll be notified of that final decision at a date in the future, okay? All right. Good luck to you, sir. Council, both of you, thank you for your presentations.
Thank you so much, Ron.
With that, the matter is submitted, the record is closed, and we are off the record.
And also, we will now be taking our lunch break and we'll reconvene at 1:45.